up, running band. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach, don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay, I cannot help that they copy. Hey, I am their dad, call me Poppy. They wish they created the set. Yes, they on my D like a jockey. When it comes to the print, I'm the blue. Who? Every complaint, draft is smooth. Supreme Elite team be the ones. Yo, I created my own school. Facts. I came from the trenches. I came from riding them benches. To proving my case with exhibits. My craft is exquisite. I find where they hiding them digits. The cancer that's not in remission. Hey, please pay attention. You can't recreate the five lenses. You can't duplicate what is written. You either gon' pay the tuition or pay for assistances, or pay the mistakes when you case it, dismiss them. I come with everything that's under the kitchen sink. I haven't slept in a week. They scared while I'm willing to compete. These scammers are devils and I keep them under my feet. Hey, they saying they win, I never take their prescription. They never coming from the plaintiff's position. I am the blueprint, blatant admission. Check it, when I talk classes in session, professionals, even the tacos respect it. Show me a win, that's not a rejection. Tell me the truth without all the stretching. These gurus are boring and it's stretching. These students are dumb, desperate depression. SETu, yeah, I'm done with this.
You're rocking with the best.
Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach, don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay. New culture, he running this shit. Hey, like he came with a gun in this bitch. Black, and he double up wins back to back. Oh, like he ain't even done with this shit. Now come to court like a dog off the leash. Dismantle the evidence, break down their claims, and he start from the top of the sheet right here. Whenever he taught, they retreat. He's a lead with his team, they supreme. He brings reality out of drink. Okay, they can't help but watch from the clouds. They trying to words in the memes. Alibi with the feds. You fuck with alibi, you be in the feds. Lawful lovey, still a rookie. Can't stand on the shit that they saying. Hey, he beat his case, he beat CAC to submission, stipulated the disposition. Westlake, he tried to give a break. Attention they didn't wanna pay. Made them max sit, they on case. Get the fuck out his face. The new culture ain't wanna play. The new culture running this shit. The new culture with debate. Anyone who think they running this shit, he take your docs and expose that shit. Gon' be acting like you never sold that shit. They copy his drip like he sold that shit. Ain't no guessing with him, gotta know that shit. Hey, you gotta know that shit. He be credit acceptance, I be Westlake. Whatever I'm serving,
You're rocking with the
best. They watch from the
best.
clouds, they copy my style but can't figure me out.
You're rocking with the best. You're rocking with the best.
AI can summarize a contract, but SETu trains you to understand what the contract is doing. The 5 lenses of the contract is a framework built inside Supreme Elite Team University. Consumer lens, court lens, corporate finance lens, regulatory lens, and investor lens. One paper can carry 5 different meanings depending on who is reading it, what system is measuring it, and what evidence can be defended under scrutiny. This is not internet speculation, and it is not a magic prompt. It is years of work, documents, workshops, filings, and professional discipline built brick by brick. Join SETu. Support the New Culture Empire on Patreon, and step into the room where serious learners train their eyes to see what others miss. Summer of Professionals reminder. Craig L. Ricks joins the New Culture Empire live on Zoom, Tuesday, July 14th, 2026, for the corporate side of mortgage finance. A $100 non-refundable deposit reserves a seat toward the $500 investment, with a 30-day replay included. Patreon.com/The New Culture Empire.
You're rocking with the best.
Woo-wee! I want to clap it up for everybody. Hope everybody's having a blessed day. I hope everybody's content. I hope everybody is doing well. Hope everybody is doing well. Of course, you already know who I am. I am your host. And we're going to have a little fun today. We're going to have a little fun today. Actually going to join the panel. Y'all going to join the panel with me. That's how we're going to do it. But I've been getting a lot of questions in the emails regarding the Summer of Professional series. You know, I don't like to respond with questions. I'd like to tend to give questions and answers. Answer the questions, but I have to ask. When professionals and potential investment bankers and potential investors, when they're taking classes regarding securitization, they're taking these classes, and yes, they're paying thousands of dollars to understand the systems behind these structures, to weigh the pros and cons, to weigh the risk assessments. Ladies and gentlemen, you are under no obligation to sit and hear this professional speak. That is your thing. But I guess the best way to answer this question is, what would you expect to get out of a professional sitting in the class, given a presentation that he gives across the world to other professionals? Ask yourself this question. Do you feel worthy enough to be even in the same room, having the same person who does this for a living speak directly to you? That you got to ask yourself this question. This is not a online guru manifestation. Let's go submit this document. It's understanding the systems. You don't complete nothing until you understand the game from multiple different angles. This is where the 5 lenses of the contract comes in. Now, I had somebody send me an email today talking about the 5 lenses of the contract. And they put the 5 lenses of the contract in a chat and sent me back what it said. And I had to tell the brother, I said, brother, this has nothing to do with the 5 lenses of the contract, of which I get it. You got to remember, we're talking over 50,000 pages of documents and over years of putting that whole thing together. So the AI chat models, it's not going to give you the 5 lenses of the contract. It's not trained to go that in depth. Like, that is created by hand, created from scratch. No other system, no other model, no other person can duplicate it. Just like the person who tried to copy my lawsuit in his own cases with credit acceptance. He just lost in May on his summary judgment. But you were copying some of my language, but once again, copying and pasting without understanding leads to losses. So why is it that I was able to be successful against credit acceptance, but this guy wasn't? You want to know what the difference was? The difference was I took 16 months to understand what I was doing. I took my time. I built it brick by brick based on the facts and elements and the circumstances of my situation. His situation was totally different, and his underlining methods and his framework was sloppily created. And this is one of the issues that it's going to continue to play these spaces. A lot of people are just mentally lazy. They're just lazy. They just want to hand it to them. They don't want to use critical thinking. They don't want to use their brain power. They don't want to sit there and figure out systems because it's foreign to them. It's a foreign language. And you know, we've been trained to stay away from things or overlook things or disregard things that we don't understand, things that our brains can't easily just pick up on. These are the things that we was meant to be trained to do. I'm telling you from experience, in order to come out on the other side on top, you have to go down this lane. There's just no other way to do it. They can talk about these discharge process and discharging the debt. But if that was so, you know, profound and everybody's winning worldwide, that method would be spreading like wildfire, and there wouldn't be 50, 60,000 judgments in favors of the finance companies throughout the courts all over America every week. The numbers are not reflecting the results. And another thing, this is not a system where $2.5 million can do the same thing and they're going to all get the same results. The system's not designed for everybody to win. The system is designed for a very small percentage of the pro se consumer borrower population to win. Hey, it's not unfair. I mean, it's not fair, but this is just what the game is. This is just how it goes. This is how the game goes. So you're either going to learn the portion that you need to learn, and you're going to get in and get out, get your wins and sit down and go that way with it, or you're going to continue to ride the hamster wheel. Now, I have no problem with you riding the hamster wheel. You can ride the hamster wheel all you want. It doesn't matter to me. Sorry, it doesn't matter to me at all. You can ride the hamster wheel all you want. But what I'm trying to tell you is, when it comes to this system, the professional world, the professional lens, you have to understand their system. There's just nothing. There's nothing that you can do. There's nothing that you can do that's going to circumvent understanding the way I like to call it from my Supreme Elite Team University, the 5 lenses of the contract. One contract, 5 different ways. And don't let that, like, people like to get scared. Like, oh, what does that mean? What does that mean? The same way I had to use this, I break it down piece by piece. Listen, we're playing in the game of House of Cards. I don't think I understand the type of game that's being played. A vicious game is being played. The game that's being played in many cases online is nowhere near in relation to the games that the way they tell you it's played. They're only going to teach from their level of understanding, as anybody else would. But if your understanding doesn't encompass the other side of the fence, prime example, I'm going to sit here and tell you how this mortgage company goes. I'm going to sit here and tell you, this is how it goes. This is how it goes. Number one, do you even work on that side of the fence? The answer to a lot of us would be no. Do you know anyone that works on that side of the fence? The answer to that question to a lot would be no. Do you know anyone that processes these types of transactions? The answer is no. Have you processed documents? Have you submitted custodial records? Have you submitted loan files? Have you went to the secondary market? The answer to those questions are no. So if you don't understand that, then you don't have a full picture of the mortgage company. It's really that simple. It's that simple. So if you're not in that field, then the next best thing that you can do your research. And you have to get in depth, and you have to be unbiased. You got to drop the confirmations and the bias at the door. Take it a step further. You connect with others that are in that field, the people that are doing these transactions every day. Why is it important? Because it gives you context and understanding, so you can stop guessing on how it works or regurgitating what you keep hearing online. We can stop guessing. Now you have your research. Now you have the professional's point of view. Now, if your research are aligned with the professional's point of view, then you have a match made in heaven. But if your understanding based on your research differs from the transactions, I'm talking about $87 million in reserves in a quarter. Most people don't even know how to deal with the $1 million. How you going to follow and track all that money? How you going to follow and track all the different parties that's involved in the securitization on the secondary market? You know, it's about 15, 4, which is important to us. How do you know each party's roles? How do you know the rights and the obligations of them? How do you even know how they get their funding? What's their interest rates on the loans they receive, on their own financing? These are the things. Yes, you have to know these things. Well, no, I'm just in a consumer transaction. No, that doesn't cut it. Because the corporate finance lens, the regulatory lens, the investor lens, the court and legal lens, that's what creates your consumer claims. I know they told you that you're in a consumer transaction, but if you look at the structure, just the structure, and this is the problem. Well, what structure are you talking about? I'm talking about beyond your note and deed of trust. I'm talking beyond the note and deed of trust. And this is where the space has not been taken. It's always going to stop at, you gave them something. You gave them the note. You gave them the equivalent of money, or you granted them this. So you already, those does not suffice when you understand how the money flows in that system. It couldn't be nowhere near the truth. Nowhere near the truth. It as a matter of fact, it's an impossibility. It's impossible for it to go down the way you hear it online every day. It's an impossibility. Want to know why? Because everything is on that secondary market is always going to come back to the underlying cash flow. Translation: the borrower's monthly principal and interest payments. That is what's being transferred, sold, pledged, meaning somebody has to be making the payment on the underlying obligation, evidenced by the note. Somebody has to be making the payment. So this is where this discharge process comes in at, because if you are not making the payment, then how are you going to explain to them that you're no longer obligated when they're totally reliant on you making your payments so they can pay their obligations? That's just like, you owe me $1,000. Out of that $1,000, I owe $800 to my creditor. Do you think about it? And you send me some documents talking about discharge or set off or take it to the treasury. I'm going to look at you like, what? And you would do the same thing as well. Because you know that if somebody owed you money, you know you would not be accepting the method of payments in which people claim or advocate that you'll pay with. You know you're not accepting no bill of exchange. You know you're not accepting no promissory note, no international promissory note. You know you're not accepting no $1 money order with the $1 scratched off and you writing the 25, 30. You know you're not accepting that. You know you only accepting the cash money, wire transfer, Zelle, money order with actual cash given in exchange for the money order. Certified check, cashier's check, meaning you take the cash, deposit into your account right there at the teller, and the teller cuts you a check right there. You know the same method of payments in which the mortgage company tells you which you can make your payments in every month. You know you would accept those same methods of payments. You're not accepting none of this stuff that you probably would try to send in to pay your bills. You wouldn't accept it. I won't accept it. So if we can just at least agree on that, if we can just at least agree on that, because it puts it back in perspective. The investors are relying on our underlying performance on the underlying debitness, which is the mortgage, the note, and the deed of trust. If we're not performing on that obligation, I'm talking about from how they see it. I'm not talking about what you learned. And this is one of the things you got to, we can't just look at it how we see it. We can't force them to see it our way. From how they see it, there's nothing that you can do besides pay. That's how they see it. Their system is structured on the borrowers making their obligations. So when we get to the nature of these obligations, and that's what we get into at SETu, the natures of the obligations. Does this obligation or does this contract accurately reflect the actual true substance of the transaction? Then we get to the X's and O's. But at no point is our arguments or our claims is 100% I don't owe, especially if you're in default. That will never be the argument. So when we look at, these mortgage-backed securities and how pretty much the secondary market pretty much funds America, you will start to understand the nature of the beast in which you're dealing with. You'll stop taking it personal, like everybody's just out to get you. Like everybody's just out to just stick it to you. And you got to ask yourself, why was that always the narrative? They're out to get you. They're out to trick you. They're out to scheme and scam you, from everybody, from the government to the state to the police, everybody. It's like they just have it out for you. Now, besides for the sole purpose of you just existing in the world, you ever wonder why that narrative gained so much traction? Because that narrative is the plausible deniability. Because if their processes, don't work, what's the biggest excuse? Oh, it's a conspiracy. They don't want the truth out. They don't want us to know. In reality, the things that you are trying to, I guess, convey to them, your rights, it's not nothing new anyway. It's not anything that they haven't heard for the past 40 years anyway. It's all the same things anyway. So social media gives you one side of the transaction. Social media gives you consumer and the teacher's belief. That's all you get. And if I'm wrong, then prove that I'm wrong. That's all I'm saying. If I'm so wrong, prove that I'm wrong. But I've had these conversations with Brother Ricks. We've talked about these things. We've had these conversations. I'm going to listen to the professional. I'm going to take pieces of what the professional gives and continue to build around that. Because if you actually think that your knowledge and wisdom is all you need, probably need to be recharged. Lights need to be recharged. Yeah, that one needs to be recharged. If you think your knowledge and your wisdom is all that you need, it's also going to depend on your interpretation. Actually, it's going to depend on your inner spirit. It's actually going to depend on your intent. We've been told that this is the place to come when you want to get out of debt, which is understandably so. We was told that we can use alternative methods that the system does not recognize as a way to pay our debts. Ladies and gentlemen, you are in a mortgage, one of the biggest transactions that you're ever going to be in your lives from a consumer standpoint. What makes you think that these people are going to forego hundreds and hundreds and hundreds and hundreds of thousands of dollars when it's so much incentive on suing you in court? Hell, when you're being sued in court in a foreclosure, it's not even because you're in default. I mean, that's what the contract says, but that's not the real reason why they're suing. Actually, your default doesn't really matter to them, not to the ones that's suing. Like, they really don't have as much dog in the fight as you think. But the status quo has to be protected. The perception and the image has to be protected. But if you think that they're suing you for the sole purpose of recouping and collecting on the debt under the contract, if that's their only reason for foreclosure, once again, we have been told wrong. But we would never understand and know the true, real reason why they foreclosed unless you knew somebody that actually worked on the other side, because they see the documents, they understand the game. The consumers, the borrowers, you will never be on this side of the fence. Hell, I mean, it's not like every day you got people that works for these government-sponsored entities willing to sit down and have private conversations with you. We can't act like that's just so normal. It's going on in our everyday lives. It's absolutely not. It's absolutely not. There are some things that your studying and your research cannot take you. No matter how much study and research that you're doing, there are some things that you have to get professional opinions, professional help on the other side. And the same thing goes for me. It goes for me too. I'm no different. That's just how the game goes. It's a house of cards up there. They're going to keep the in-house. You can scan the QR code, some more information. I mean, I have quite a few people, quite a few that's already reserved their seats. You can reserve your seats up to the 10th, July 14th. Ooh, July 14th, we are going in. Y'all, interesting person, Leah Daniels live. Hold on, let's hear what's going on first before I see.
Hey, here's the MCO. You You got 30 days to register the vehicle and say it's okay, great, cool, thank you. You walk out. Why is this? I'm not gonna fucking argue. I have the shit in my hand and clap and argue these motherfuckers. I'm citizen. I'm right. I'm one bus far away from giving a shit.
You're precious. I will tell you, I say that, same thing. I can say whatever I want.
So this guy, Mark K, he's supposed to be some specialist. And I remember we was on a panel together in TikTok, and I made him look completely foolish. And let's see.
But I didn't get an MCO like I was saying before, but I didn't know this process at the time either. So
Well, here's looking at the MCO that my law partner Sean figured out, and to this day he still has it, and to this day they're still pissed with it. They can do about it. But he bought his car. The lien holder was on the MCO. Flat out.
Let's see. Let's see if I can find it. What's the name? Lee Daniel. Yeah, I don't even think I want to. I don't even think I want to. Which I think. I should get on there. Because they don't want to they never want to have the conversation. I'm gonna be honest with you, y'all. They don't ever want to have the conversation. They want to gaslight. What the hell? Let's get to let's see. Let's do it. Let's do it. Let's do it. Lee Daniel. I know this is about to turn into something. All right. 456. So let me share my screen with y'all. Y'all, these people, boy. So let's. Look, private banking resolution, security agreement, UCC, hold harmless, trust account, Fidelity Vanguard. It's the same. Look, templates, ebook, link in bio. It just.
The manufacturers, because it was fucking up their profits.
Yeah, I do remember.
I did the math. I bought a 2012 Honda Cross Tour.
Let's
brand new. Also bought 2012 from a dealership in Houston. And I did the math on it. That car from dealership, if I bought it, I think I spent 25 and some change.
Go with.
If I bought that car from the manufacturer, I'd have paid maybe
Coach
$8,000. It was less, but it was less than. I know the figure was less than 10,000.
Manufacturers suggested retail offer. These are most people knew how much juice there was, how much profit there was from the sticker to the deal to the file in the dealership. I mean, business, but I don't want to hear about your lights and your advertisements and all that other stuff. That ain't none of my business.
You see our question right there? Lee Daniel, how did the coupon method go with Coach MT? She's not
going. They sit there and pay $10 extra because they put nitrogen in the tire. I'm sorry. Can you prove where all the noble gases were taken out of the tire and it's just nitrogen?
Won't answer the question.
You're positive there's no O2 in that. That noble gas, they're called noble gases. There's no other noble gas except nitrogen in that fucking tire. I'm not paying that. How do I know?
Sam, the new Coach of Empire, you see? Hold on.
By the way, all the shit that comes with.
She won't answer the question. You want to know why she won't answer the question?
They didn't put that shit on there.
No, nothing.
Valerie, you're going in and out.
Dealerships.
These are all the
In and out real bad. And if you guys are requesting to come up, I don't see any requests down here. Sorry, go
Can you hear
ahead.
me better now?
Yeah, it just,
Okay, sorry about that.
These are all the people. Every time they're on the panel, it's all a complaint how the system's doing them so wrong.
Sorry.
How the system's doing them so wrong. It's just
no, I
so
think
wrong.
there are, I think I can have 9 boxes.
Nothing.
But go ahead, you guys.
Told you. She ain't gonna answer the
But
question.
the dealership, all they did, they
She ain't gonna answer
This
the
is a
question.
criminal offense.
Okay, so
sir.
under the Constitution, there's 2 jurisdictions. One is under the common law and the other one is a condition of contract. On the colorable elements of a.
I don't know whether or not you're getting
Which
your.
2 of these jurisdictions will you
Let
hear
me
this
tell you what
case
you're
from?
not going to do today, Mr. Trammell. You are not going to interrupt me when I'm speaking. Do you understand me?
I think contempt in jail time is appropriate right now.
I'm not interrupting you.
Okay, now you are here for arraignment. And I'm
Well,
going to ask
understand
you.
that, but you're not answering my questions. I can't adequately answer the question until
Here?
you answer.
He got caught with a gun, and now listen. There's no common law jurisdiction. Common law is a doctrine, and common law can be applied to grant equitable relief, meaning being fair. Not so necessarily means that you have these rights under a particular statute, but it's the principles of fairness, which they can give equitable relief. It's not an actual jurisdiction like a court. Here's the comment. No, it's a construct. It's not like a physical live jurisdiction of the court that you can go into.
What's mine?
Criminal charges. Okay.
So this is what I'm gonna do. I'm going to go live on TikTok as well. So I'm gonna go live. I'm gonna go live on TikTok as well. And that's how we're gonna do that. So let me go live. We gonna double. Ooh, what happened? We're gonna double live. I don't want to upload a video. Hold on, let me go back. We're gonna go live on TikTok. Y'all still be on this side, but y'all won't be view profile. How do I go live? I forgot how to live TikTok studio. All right. So let me get my let me go live. Damn, it's hard. Hey, y'all, it's hard to do this from it's hard to do this from actually I'll do it like this. How about this? I'll do it like this. I'll do it like this. I got an easier way to do it. I'll go live from my phone. I'll go live from my phone. I'll go live from my phone, and they want to use the device. Yeah, I use my device. All right, so I'm going live from my phone. So let's get out of here. And it should be, y'all, if you have Verizon, change your plans. Verizon is trash. Hold on. All right. So let me refresh because I'm going live. I should be going. There we go. There we go. Going live. I should be going. There we go. There we go. I'm going to mute because y'all can still hear me too. All right. So we are going live on TikTok as well. I can mute out on this side because I'm live on my TV. And let's do it like this, full screen. Yeah, I haven't really went live on my Stefan Diggs. Invite you to co-host. Let me just accept. Let me see what's going on. Oh, request cancel. Oh. TikTok. I keep forgetting. Y'all get in here. Hey, we gotta talk about this 5 lenses of the contract, y'all. We gotta talk about it for a second. We gotta talk about this 5 lenses. I don't even know how to. We gotta talk about this 5 lenses because let me share the screen. We gotta talk about this 5 lenses, y'all. I know we always think that as soon as somebody I know I'm TikTok. I know I'm John like a trendsetter. I know I'm a trendsetter. I know a lot of information people want to take and go put it in their chats. But let me tell you this. When I talk about the 5 lenses of the contract, it's nothing that you could put in a chat and get the 5 lenses what I'm talking about. We talking years of building the whole framework from scratch. We're talking years. We're talking over 50,000 documents, where the majority of those documents is not even available online. Like, you got to have credentials to access them. Like, I was able to get access to a faculty staff. I was able to use someone else's credentials. So this is stuff that the professors and the college professors, like when they put out their papers, other faculties, other staff members at the universities or the universities across America, they get access to. So a lot of the documents that's in it. So when I say the 5 lenses of the contract, the framework is not nothing that you could put in chat GPT. You can't put it in a box. You can't put it nowhere because it's not trained to go that in depth. You already have to have all that down pat. And then the infrastructure is built from there. But if you try to put that in a chat, you're not going to get the results that you think you're going to get. You're going to get the same old generic, remember, Chat GPT and all that, that's generic. They're going to pull the generic versions. They're not going to get the in-depth where looking at the contract multiple different ways. You're not going to get that. Matter of fact, let me share that with him because the brother sent me the email today. Why can't I share? I used to be able to. Let me share this right quick because I ain't gonna lie to you. And it's patent pending. So I'm not even gonna lie. Yeah, we're not even about to start. We ain't gonna start that. I mean, y'all, everything is not just running through a chat. I can't even share. I don't know if it's restricted or not, but I hope I ain't do nothing. Yeah, TikTok do be restricting me sometimes. Here we go. Here we go. Sometimes it do be happening. Let me do it like that. Yeah. So when we talk 5 lenses, y'all you can't jump to 5. You can't just put that in a chat, y'all. I'm not talking about that version. Remember, my version, that's part of the Supreme Elite Team University. That's what I built Supreme Elite Team University around. So that was being built in the background for years, several years. You can't just go type and think you're going to get the same output. And it's going to get dangerous because you think that the chat, AI is good for summarizing. AI is not really good for giving you complex answers. It's not really good for that. Like, you literally have to already have an understanding of the systems in order to navigate through it. Remember, it's only as good as the prompts you put in. But if you don't understand the contract or the transaction from multiple lenses, you can't get the answer from somebody. You can't, AI can't give you the answer. You already have the pertinent knowledge. That means you had to do your research from out the mud. You already had to develop the understanding through years of repetition. And when I say the 5 lenses of the contract, the 5 lenses of the contract is a framework that I've built to allow my SETu students to look at the contract from multiple different lenses, meaning taking one contract and looking at it 5 different ways. Now, the 4 different ways, the first 4, those ways of looking at the contract allows you to analyze and structure your consumer claims in a more in-depth way. And then instead of the standard FDCPA, or they violated this statute. No, actually, the other 4 lens will help you understand the underlying substance of the transaction, which contradicts the contract in itself, which contradicts the form of the transaction. See, we move through the systems to get to the substance, because that is what tells the full picture. It's not a talking point, and I don't do this for my own health. When I say I can look at one contract and give you 5 different views of it on 5 different ways it's seen. And why is that even? I don't do that for my own health. But it's important to understand the multiple lenses of the contract. It's important for you to understand it, because if you're solely based on the consumer, you don't even have the understanding on why the contract derived, where it derived from. Why are you paying all this back in interest? See, the number one thing is the answer. Why? We can talk about what they're doing all day, or they're doing this in the securitization, and they're doing this, and they're doing that, and they're doing this, and they're doing that, and they're doing this. But the real question is, why are they doing these things? What is the reason why they're doing these things? Why? Why are they doing it like this? There is a reason. It's always a reason. And then that's, once we understood the why, now that allows us to start to pinpoint and break apart whatever their claims and their assertions were on the contract. So when you're fully equipped with the SETu 5 lenses, this allows you to have the confidence to beat them to the punch. See, there's no more, okay, I'm going to stop paying, or I'm going to send a document in. Hopefully it hits. But if it misses, then they're probably going to take me to court. Then I'm going to play pat. I'm going to set a trap for them. Because now you have allowed them to take control over the transaction, not the transaction, the litigation. You allow them to take control over it. Now they choose the venue. They choose what happens. They choose. Prime example. This is one of the dangers of copying without understanding. There was a gentleman, I'm not going to say his name, but if he's watching, he knows I'm talking directly about him. I'm not going to say his name. This is a gentleman who decided to take my work, copy and paste it into his own lawsuit with Credit Acceptance Corporation. Not to mention, when you look up the statistical numbers on what I was able to achieve against him from a pro se plaintiff and in federal court, and citing the same accounting stuff that a lot of people get theirs thrown out every day, it came back as to a 0.001% chance of success of me not getting my case thrown out. So, and along with that, I sent the motion with temporary restraining order. 2 things at the same time. You ain't never really see them both go like that. So he sends me in the DMs a couple months ago. He sends me his motion for temporary restraining order and his lawsuit that he filed against Credit Acceptance. 1 second, y'all. Somebody, who's that knocking at the window? 1 second.
No pressure, nah, I ain't feeling no pressure. No, I ain't stunting her, man. She wanna get on top shit, I'ma let her. Come here. With this street code, I'll buy to the letter. It's just me against me, I ain't feeling no pressure. There's no hoes barred with the shit, nigga, everything gon' go. Hoes come to see me, I miss a heart and hustle up with the flow. I used to stand in the crowd, but now I'm the star of the show. My 10 in the field of play, I know you niggas looking down at my toes. I'm only smoking no pressure, I'm digging graves with the shovel. Just like Pac in my nigga bags, you should know let it be a rebel. They watch the corner for a stat, watch out. My little nigga be the lookout. You broke that shit embarrassing, like the drunk uncle watch the cookout. My 10 down, you got a foot out. I fuck my bitch, never pull out. A bitch drowning my drip flicker, she gon' feel the stain from my wrist. You disrespect on that click, I put the tech on your lips. No handouts, they gon' go get it litty, cut a check for a quick. No pressure.
Right. So he sends me a motion. He sends me his complaint and his motion for temporary restraining order. I'm not going to expose the text messages, but when you file a motion for temporary restraining order in court, one of the biggest indicators whether you're going to win or lose your case, one of the biggest indicators is whether the judge either grants your TRO or at least makes the other side respond to it. And that's bare minimum. You at least got to get the judge to make the other side respond to it. His motion for temporary restraining order was, as a matter of fact, let me go ahead and see if I can pull. You know what? I think I have it. I'm not going to talk about the case, but I did a Supreme Elite team. I did it like a check. I did it like a audit on his case, what he filed. Supreme Elite team. I did an audit on his motion, right? Hold on, TikTok. I gotta find it. I gotta share it to my computer. Y'all hold on 1 second. Oh yeah, we gonna do it like that. We gonna do it like that. We are definitely gonna do it like that. Supreme. I'm gonna have to do it. Damn. We're gonna do it like this. All right, so let me share this. Let me save it first. And let me do this. Let me do this. Here we go. So I'm gonna share it to my map book. All right, we got it back. We got it. So let me do it like this. Let me open it up. Yeah, man, you can't put the 5 lenses of the contract in a chat. No, it's the framework. It's totally different from what you think it is. It's not going to say the same things. Sorry. I'm sorry, it don't work like that. It don't work like that. You cannot put the 5 lenses of the contract. You can't put that. No, you cannot do that. It's not even going to pull. It's not even going to the underlying functions, everything that went into it. It don't work like that, man. It don't work like that. So when the brother sent me that, when he sent me that stuff, bro, it was just all wrong. I mean, it's all off. It didn't hit the market. It totally missed the mark. It totally missed the mark. Now, where is it at? Hold on, I just had it. Hold on, I just had it. Wow. I literally just had it. Okay, so let me do Supreme Elite team. Let me see. I literally Supreme Elite team. And yeah, I literally just had it. I literally just had it. Is it this? Yo, I literally just hold on 1 second, man. God damn. Doc 4-2. It's Doc. Okay, I got it. All right, I got it. It's Doc 4-2. Doc 4. Here we go. Here we go. Now, it's the brother. Let me see if I can. Let me see if I can do it like this slippery ass table. See if I can. Got to be kidding me. This slippery ass table. Hey, yo. It won't work, y'all. It won't work. Hold on. It's probably the best you're going to get. Michigan 3rd Judicial Circuit, Wayne County. Documents reviewed. Verify complaint for equitable relief and order denying TRO. I just want to see if my screen's still being shared. I just want to see if it's still, if YouTube can see it, should be able to see it. All right. Yeah, you should be seeing it. Scope of this report. This report provides an objective legal analysis of the structure of plaintiff's motion for temporary restraining order, the denial of the order, legal vulnerabilities that may expose the complaint to dismissal, the absence of controlling legal authority supporting the theories asserted. You see that? The absence, not one case law cited. And you can tell that it just went straight. He went copied my case against them. Everybody, quite a few people has tried it. But when I look up their docket sheets, as a matter of fact, in the end, we're going to see the docket sheet. You're going to know what happened in that case. And this is what happens when you try to cite the new culture empire without the new culture empire's understanding. Remember, it took years to build this understanding. And many people are trying to get around the years it took me and hurry up and get to the empire. It don't work like that. The absence of controlling legal authority supporting the theories, the procedural substantial risk under Michigan law. This analysis is conducted from a litigation risk perspective, similar to how opposing counsels might evaluate the pleadings. The plaintiff filed a verified complaint seeking declaratory, injunctive, and monetary relief against defendant. The complaint asserts multiple theories, including declaratory judgment. Why does it keep doing that? Declaratory judgment, and that the debt obligation has been satisfied. Fraud in the factum. Remember, every time you say fraud, I'm looking for the who, what, when, where, and how. Violation of consumer protection statutes, accounting and tax legal theories regarding securitization. Oh my gracious. Bruh. Authorities or judicial precedents in the absence of such authority may weak. Hold on. Yo, this is garbage. That's page 1, 2, and 3. The plaintiff also filed an emergency motion for temporary restraining order seeking to prevent enforcement of the alleged debt. The court denied the motion for temporary restraining order. Denied the motion in 2 days. The legal significance of the TRO denial. The court denied, and this is what I sent to him after he sent me, after the motion for TRO was denied. So basically, this is basically saying, bruh, this is how I see your case ending. The court denied the request for a TRO under Michigan Rule 3.310, concluding that the plaintiff failed to establish the elements necessary for injunctive relief. Remember, court rules of procedure, you can come with your claim, but if your claim is not in line with the court rules of procedures and substantial case law to support it, remember when I said what happens? Remember, we always think it's just about the facts of our case first, and that's all we need to prove. The court cited Michigan precedent stating that economic injuries do not constitute irreparable harm because they can be remedied through monetary damages. The denial indicates that the court presently views the alleged harm as financial in nature rather than irreparable equitable harm. One of the 4 elements to at least get the judge to get the other side to respond to a motion for TRO. Temporary restraining orders, injunctive relief, emergency TROs are extraordinary remedies. And less than 0.5% of pro se litigants will ever even get a win, an injunction, a temporary restraining order in that manner, and me included. And less than 5% will ever even get to the point where the judge is ordering the other side to respond. So when you look at my case against them, if you look at everything in its totality, I had less than a 1% chance of getting the results that I got. The odds were less than 1%. Or take it all together. Under Michigan law, an injunctive relief is considered an extraordinary remedy, and courts generally grant such relief only when monetary damages cannot adequately compensate the plaintiff. Elements required to obtain a temporary restraining order in Michigan. Damn, YouTube, I hope y'all still on. I think so. Hope they're still on. Give me 1 second, TikTok. Let me see something. Let me just see if y'all still with me. Oh yeah, they still with me. Yep, they still with me. They still with me. They are still with me. Sometimes you don't be knowing with this MacBook, man. Yep, they still with me. They still with me. They are still with me. Sometimes you don't be knowing with this MacBook, man. Yep, they still with me. They still with me. God damn it. Sometimes you don't be knowing with this MacBook. Hold on. Yep, they still with me. They still with me. God damn it. How I'm gonna do this? Hold on. Yep, they still with me. They still with me. How I'm gonna do this? Damn it. What the hell? Hold on. I got. What the hell? Hey, TikTok. Hold on, y'all. I don't know why I'm still doing this. TikTok, I don't know. Hold on, y'all. I don't know why I'm still doing this. TikTok, I don't know. Viewers can't hear me. TikTok. All right, so I'm gonna have to viewers can't hear me. It's gonna be this in the background because TikTok. All right, so I'm gonna have to viewers can't hear me. This is crazy. All right, TikTok. I'm gonna exit this live. I'm gonna come back in the voice chat. Go back in the voice chat because I don't know how this. It's not gonna work like this on the voice chat. I don't know why it's doing that. I really don't know why it's doing that. I have no clue why, bro. This. Woo-wee. All right. So, all right, we back. Y'all, it's still. How about now? How about now? Okay. Oh, that's the problem. Hold on, YouTube. We about to get back to it. That's the problem. That's the problem. I see what happened. YouTube was still in the background. YouTube was still in the background. There we go. All right. That was the problem right there. YouTube was still in the background. All right, it's not in the background anymore. So this is recap. This is a dude who copied my case and you try to use that. Then he lied about it. I all know he did, because as soon as my lawsuit was done and finalized, right, like, oh, he has his own lawsuit against him from a situation that he could have took care of 5-6 years ago, several years ago. So if the timing was a coincidence, another thing, a lot of things that I use, I researched the circuits. I researched them for 6 months straight. I never found the claim that was similar to mine. But all of a sudden, a lot of things that I was saying, like he was like word for word. Like, you know how much in depth you have to read, at least 200 first pages to get to that one part. So I'm like, bro, you ain't reading no 200 pages, because I would have found your case. You would have been a success. So they repossessed the vehicle. You get what I'm saying? You get, I'm like, nah, bro. Nah. So under Michigan law, a party seeking injunctive relief must establish 4 elements. This is the universal standard for both federal and state courts, and many get these denied. It is only when the court orders the other party to respond, or in emergency circumstances, when a TRO is granted preliminary and the other party is ordered to respond, is when the 4 elements are satisfied. Number 1, a likelihood of success on the merits. That is the number. If you want to see how your case is going to look, what's the consensus, file a motion for temporary restraining order. The number 1 thing is the likelihood of success on the merits. Number 2, irreparable harm absent the injunction. Number 3, the balance of harms favors the moving party. 4, the injunction serves the public interest. Michigan courts consistently hold that purely monetary damages injuries do not satisfy the irreparable harm requirement, because there's 4 requirements that's needed. Many pro se litigants fall into this trap, and what Thomas calls chasing the money through litigation. When a complaint is mostly monetary damages, filing a motion for TRO effectively shoots the pro se litigant in their own foot. Thomas stresses, never chase the money, chase the merits, because it's the merits that brings the money. Typical forms of irreparable harms recognized by the courts includes loss of constitutional rights, destruction of unique property, disclosure of trade secrets, imminent harm that cannot later be remedied. Financial loss, credit damages, or contractual disputes are typically viewed as remediable through damages rather than injunction relief. This is the nuances of court, Thomas stresses. 4, structure pleading deficiencies. And yes, I have the text messages between me and him talking back and forth in the chat about his case. And I'm going to show you, actually, the docket is on my page in TikTok. We're going to break the docket down after this. Several aspects of the complaint Thomas and his professional team believe may present challenges under Michigan pleading standards. Number 1, absence of supporting case law. One of the biggest and notable weaknesses in the complaint and in many pro se litigants' complaints is the lack of supporting judicial precedents. The instant complaint relies heavily on accounting standards, which are generally governed under federal law and does not provide a legal cause of action. Citing the ASC does not help any pro se litigant unless it's cited to support the legal cause of action. Moreover, the ASC must be tied to the litigant's direct claims and not just cited. IRS tax provision. I swear to God, he just copied me. I swear, but the topics that I raised, but you don't see it in pro se spaces. You don't see it. You've never seen it before me. I searched all circuits. I was in Pacer for 6 months, probably racked up a $500 bill. Many pro se litigants mix the administration of tax laws as consumer defenses, such as the request for tax returns, etc. Tax returns serve only evidence the tax liabilities of a person or corporation. In a consumer transaction, it serves no purpose. In Thomas's lawsuit, he cited, as plaintiff here cited, CFR 1.118, not as a defense, but to show the federal courts that if this was a tax court issue, the IRS would view the transaction in the same light as Thomas. He cites the same regulation. It was the exact, I'm like, bro, they don't even talk about that stuff. SEC filings, one of the trickiest of them all. Citing SEC filings with no foundation as to its applicability to the pro se plaintiff's case. If not argued like a class action lawsuit, it comes off just as using SEC filings as a consumer defense. Furthermore, anything related to the SEC is never concerning a consumer. Thomas did a very rare thing, tying the regulatory and investor relations into his consumer contract, aka 5 lenses of the contract, but not just throwing that in the chat. You actually have to know what the relations are. And you, not AI, has to tie those things back to your case. This is what I'm saying. The 5 lenses of the contract is very rare. You're not going to find it outside of SETu. You are not. Man, you have professionals that said, damn, this is good. I have a guy that works for Deloitte, one of the big 4 accounting firms. None of them understood when I told him to bring that. When I told him to raise that to his supervisor, none of them understood what he was talking about. Hey, TikTok, shout out to, it's hard to see. Darren, I was waiting for you to go live. Shout out to, God damn it. Shout out to Darren. Yeah, I was on there. I was going to go live with you on the desktop on TikTok while I was on YouTube at the same time. But I'll tap in with you though. A very complex thing to do. And state venues are never the venues for these type of claims. Financial reporting frameworks. A pro se litigant that uses financial reporting frameworks in a consumer transactions bears the burden of connecting how a company reports on their financial statements has any relevance to their complaint. Another highly complex issue. And this is when I knew that he copied my case, because I raised nothing but issues where the success rate is 0.1%. So if you try to copy it, you may lose. I'm just being honest with you, with no full understanding. And if you look at 16 months of investigation and putting the pieces together, you're not going to understand it by reading 2 or 3 paragraphs and think you really to throw it in your complaint. Absolutely. The plaintiff's complaint is missing controlling case law from Michigan courts, federal courts, and other jurisdictions to show consistencies among the sister circuits on the issues raised in the complaint. All courts generally require legal claims to be supported by statutory authority or judicial precedent. In the absence of such authority may weaken the legal plausibility of the claims. Reliance on financial accounting standards. ASC standards govern financial reporting and corporate accounting practices. However, as Thomas states daily, ASC provisions are not statutes, are not regulations enacted by government agencies, do not generally create private rights of action. State courts typically resolve disputes involving contract law, statutory consumer protections, and secure transactions under the UCC. You notice how that is the corporate finance lens, and down here is the legal lens. You notice how these lens has no real direct connection. This is why I say the 5 lenses of the contract. It's a intricate, woven framework that have tied all the issues that normally are not connected. I make them all connect. This is why you cannot put the 5 lenses in a chat. Think it's going to spit out the same thing that you will get if I broke it down to you. As a matter of fact, they're going to spit out the opposite. Courts generally do not adjudicate disputes over GAAP or accounting standard compliance in consumer debt litigation. Also, arguments based solely on accounting standards may be viewed as irrelevant to the legal enforceability of a debt contract, as Thomas has repeatedly stated. Accounting is not a legal cause of action. It is only used to support the underlying nature of the, I was just thinking about it too. Support the you can plug that up somewhere else. Okay. Probably over here. Right. Yeah. To support the underlying nature of the claims presented. And I rarely ever argue correctly by consumers, as these claims are generally raised by very experienced litigant experts and in class action lawsuits. I keep trying to tell y'all, I'm not a consumer argument. I argue like a class action lawsuit. It is it's very complex when I get in the picture. This is why you cannot duplicate me. It's impossible. In order for you to be able to duplicate me, every single facts and circumstances has to be 100% identical. And you have to be in the same state. That's the only way you can pull it all off. And then you still have to understand. So you have to be able to communicate it, not just words on paper. What if you had a hearing? What if the judge told you to make the connection right in front of the judge? Will you be able to do it? Or would you rely on the motion or read your motion into the record, which the judge already read? Because believe it or not, some people, when they're in court, make their arguments, they think making their arguments is reading the same motion that they filed into the record again. The complaint relies extensively on Financial Accounting Standards Board, Accounting Standards Codification, provisions, highly technical terms, which takes pinpoint accuracy with their application. Many pro se litigants who argue the FASB and the ASC do not have the expertise to not only argue, but substantiate these claims in a legal setting. Use of federal tax provisions. The complaint relies on tax provisions under the IRC and Treasury regulations. This is not a tax court, so any reliance on these provisions should be purely in example form. Thomas's lawsuit did not rely on the tax provision as a defense. As mentioned earlier, it was relied on to prove that if this matter was brought in a different venue by the IRS would come to the same conclusion. This takes extensive understanding of the tax laws and how they apply and use to paint a picture rather than as a defense, which plaintiff appears to do here. The provisions cited, the tax provisions he cited in his complaint governs taxation of financial transactions, income recognition rules, corporate accounting treatment. These regulations never determine whether a borrower's contractual repayment obligation has been extinguished, and the courts may get lost in plaintiff's arguments. When it gets back to court, it's only going to get back to that. You know they watching from the clouds. They don't want to come in. They watch from the clouds because they don't want anybody else to see them in the chat. They'll be like, hey, bro, you be saying the same thing on your live. They'll watch from the clouds. Yo, these gurus are scared that somebody in the chat is going to, hold on. Red, you were just teaching that 2 days ago. What you got to say about it now? Especially when we got case law, the courts shutting it down. They'll stay on outside and TikTok so you can watch from the live on the outside. You don't necessarily have to be in the live. They're going to watch from the outside. And y'all, I don't know what happened, but that live court with my client when she was in court. Y'all, we are well over 10,000 views. We get to 11,000 views, 100 new subscribers, gained 100 new subs in a day. Y'all, let's keep pushing. Let's keep pushing the new culture empire and the algorithm, man. Shout out to those. Shout out to y'all. 100 new subs in a day. I lost 13 in a day. 13 people unsubscribed. Gained 105 more. Hey, even when we lose, we win. The complaint does not cite authority holding that tax treatment of financial instruments discharge consumer debt obligations, and plaintiff will not find one as one does not exist, thus making this argument deemed frivolous and may open the plaintiff up to a motion for to dismiss for failure to state a claim upon which relief can be granted. And he's going up against credit acceptance, and this is how I'm dissecting his case against credit acceptance. If one person that knows how to beat credit acceptance, it's me. In a legal courtroom, it's me. I know how to beat them from top to bottom. I know how they operate from inside out. Reliance on SEC filings. Many pro se litigants in the social media space rely heavily on SEC filings in their litigations. The complaint cites statements from defendants' SEC filings almost identical to Thomas's citations. Plaintiff may be under the impression that SEC disclosures tie directly to his case when SEC forms are intended to provide information to investors and regulators regarding corporate financial conditions and business practices. Thomas's complaint stepped into uncharted territory with the merging of regulator and investor relations into his lawsuit, a feat that many seasoned attorneys cannot do. Once again, this is another highly complex argument that plaintiff ceased to make, but did not lay a foundation for them, did not cite case law to support his claims, and he used the SEC filings in a way that it appears that he is citing them as a consumer defense rather than evidence tied to his underlying cause of action. Woo-wee! Y'all, tap the screen, hit the like, hit the share, scan the QR code, reserve your seat. Reserve your seat for the mortgage, for the mortgage presentation in the Summer of Professional series. There must be a reason why you are citing SEC filings and as a legal defense. It's never one of them, as the SEC filings do not in themselves govern consumer transactions. Courts have been universally consistent that SEC disclosures as general corporate information rather than dispositive evidence of contractual liability. Only the court, I'm telling you, you can have the SEC, you can have 5,000 filings you want. When it gets to court, it's the, you know what's going to go back to with the courts? You know what's going to get to a court? I'm going to tell you what's going to get to in court. Oh, this is pulling up. When it gets to court, you know what the judge is going to look at? You can have the SEC accountant. You can say all that one. You know what the judge is looking at? Who owes who has the obligation to pay, who did not pay. Okay, this contract here, who has the, should this person be required to pay any more than what the defendant economically recognizes? That's all they're focused on. The debt, the note, secured rights, that's it. You have to use what the courts are really looking at, and your legal cause of action has to cause confusion in what the courts generally look at. ASC and accounting and SEC filings are not legal defenses. I know the pro se gurus, they forgot to tell you that. They're not legal defenses. Fraud and effectum allegations. The complaint, once again, cites another highly complex argument, fraud and effectum, which is narrowly which is a narrowly defined legal doctrine. FITF requires proof that the signer of a document was misled as to the nature of the document itself, believed they were signing something fundamentally different. In most consumer lending disputes, the borrower is aware that the document being signed is a loan or financing agreement. Given the procedural history throughout all state and federal courts, the likelihood of succeeding this argument is 0 to none. Allegations regarding later financial transactions or accounting treatment generally do not satisfy the elements required for fraud in effectum. 6. Federal credit reporting claims. Plaintiff shifts to consumer claims in the complaint. Thus far, plaintiff has tax arguments, accounting arguments, securities arguments, and consumer claims in this complaint against CSC. He mirrored mine, copied 100% from me, but he lacked the understanding. So this is why once he just got all the buzzwords and just copied and paste, when he couldn't stand on it, when he couldn't find case law to support it, okay, I'm done copying Thomas. Now let me get to what I really know. This is when you see the federal credit reporting claim. You see how all over the place he is? You see how all over the place he is? All over the place. Had no clue. Copy. And then when I told him, he started getting jazzy with me. You're not the first to do it, and you won't be the last. I say, okay, you can say that. Cool. But why are you copying me? You should be copying someone else if someone else was the first to do it. You're not going to find another lawsuit against them like mine. You're not. And I've went over all their lawsuits filed against them, state and federal court, dating back to the 80s. Not one. That's why it was a 0.01% chance that I win. Plaintiff shifts to consumer complaint. That's complaint against CAC. Nearly identical to Thomas's structure. But plaintiff here has given no legal authority to substantiate his claims. The federal credit reporting statutes, such claims typically require proof that the consumer disputed information through a credit reporting agency. The furnisher received notice of the dispute from the agency. The furnisher failed to conduct a reasonable investigation. These elements are not specifically alleged in the complaint. The claim may face procedural challenges. I told you. The claims that you raise, I don't give a damn what your arguments are. I don't give a damn what you're telling me, oh, this is what they did. I could give two rats' asses. I'm looking at the structure, I'm looking at the procedure, I'm looking at the rules, and I'm looking at substantial case law. If those things aren't satisfied, you have no claim. Everybody, when they send me their case to look at, they always want me to see where they coming from how they feel, because they're too emotionally involved. They want me to be like, yeah, you're right. Yeah, oh, I see that. Oh, no. I'm looking at it from I'm looking at it how the other attorneys are looking at it. Now, this is just my finding here. So it shouldn't be a surprise why Credit Acceptance filed a motion for summary judgment and they won. He lost in citing some of the stuff that I cited in my case, and he lost. This is where understanding comes in at. I told you, you cannot. They don't want to listen. And don't talk to me no more in the text messages. Every single one of them, when I prove to be right, they all disappear. They all disappear. And I told him, bro, I know how they operate. Pay my services to draft your complaint for you. He started sending me copies of some books and stuff he studied, had all the pride and ego. And when he lost, what happened, y'all? He ran away. Listen, I charge $350 to do an audit on the motions that you filed. Bro, I've been waiving that as of lately. I've been waiving it as of lately. because I'm more concerned with you looking at the reality of your case instead of walking you off the fiscal cliff. That's not saying I don't reserve the right to reinstate that fee anytime I want, because that is my right. But if you look at this right here and we look at the docket when we're done, this is going to prove 100% that I was right. I know how to read case law. I know how to anticipate how a case is going to go. I mean, I got 22 years of experience of being in the courtrooms. I know what it's like, state and federal. I remember when I started out having my motions smashed to pieces, to the point where my motions and pleadings today rival top law firms in the world. Monetary damages and return of proceeds. And this is one of the main sections right here where I told him, do not argue. Don't worry, Darren. They're on the outside. They're on the outside. They're watching from the outside right now. I guarantee you, when we get on the panel together, somebody gonna bring this up. This is number one mistake nearly 98% of pro se consumers make in their litigation, attempting to chase money through litigation. Many pro se litigants believe that they can recover securitization proceeds through litigation. That attempt will almost always fail, and it will most certainly hurt their chances for any settlement talks. The complaint seeks monetary damages and references alleged financial proceeds related to securitization transactions. This is a myth circulated online that pro se borrowers can recover securitization proceeds. That will never happen. The investors are the only ones entitled to the proceeds, and the plaintiff here is not the registered beneficial owner of any securities issued from the issuing entity. Unless the borrower can show that he was in fact the registered beneficial owner of the securities issued, this argument will fail. And yesterday we read case law where the federal judge says you have to be an intended beneficiary, not a implied beneficiary or incidental beneficiary. And I wrote this before we read the case yesterday. And we have a federal case that's backing this up. Courts, both state and federal, have consistently held that the borrower is neither a party to the securitization, nor are they entitled to any proceeds derived therefrom. We read a case law yesterday where the federal courts agree with me. Remember one of my sayings? If you don't want to hear from me, I promise you, I will let the judge tell you. I'll let the courts tell you. I guarantee you they're going to say mostly the same things that I'm saying than when they're not. I guarantee that me and the courts, both state and federal, are going to be on the same page more than we're not. This is an investor class action lawsuit argument, and plaintiff will not survive this claim. In litigation involving consumer loans, courts generally analyze damages under traditional legal doctrines such as breach of contract, statutory violations, fraud, unjust enrichment. Proceeds generated through securitization transactions typically arise from financial agreements with plaintiff, which plaintiff is not a party, between institutional parties such as investors, lenders, and financial intermediaries. When a person fully understands how securitization works from a corporate, regulatory, investor lens, they will understand that from a consumer standpoint, that claim is an impossibility. Since the borrower is not the party to those agreements, this court will most definitely conclude that the borrower does not have a legal entitlement to the proceeds generated by those transactions, and the borrower may open himself up to the possibility of a motion to dismiss based on this argument alone. To recover monetary damages, a plaintiff must generally establish a legally protected interest, an injury to that interest, a causal connection between the defendant's conduct and the injury. The elements. You keep worrying about what you want to file, how you file it, the core elements. And this is why I'm saying, yes, we may wear the label as a pro se, but I am nowhere near a pro se litigant in court. I'm a professional in court. I'm just like their lawyers in court. I'm just like them. I don't see myself, no, I'm on par with the top law. I'm on par with them because I have to be. When damages are based on the secondary market transactions or investor funded structures, courts may question whether the plaintiff has standing to those claims, to those proceeds. Has standing to claim those proceeds. Just like we read in the case law yesterday on TikTok. The judge is literally saying the same thing. And I wrote this 5-6 months ago. March. 4 months ago. Case law 4 months later supporting it. Section 7, separation between consumer debt law and capital markets. Consumer debt disputes almost certainly focus on the existence of a valid contract, the amount owed, the identity of the parties entitled to enforce the contract. Securitization transactions, by contrast, occur within capital markets in financial reporting frameworks. Courts treat these two areas as legally distinct, and the plaintiff has not produced evidence that will make the court interlap these areas. This is why my SETu 5 lenses of the contract is so rare. The odds of you connecting the corporate finance lens, the regulatory lens, the investor lens, the legal lens, and the consumer lens all into one, all interconnected, you have a better chance of hitting the lottery. And when I started to see it, y'all, I knew it that I stumbled across a gold mine. I knew that, hell, lawyers don't even understand this right here because they're not trained to wedge those topics together. You got to remember, every topic, every lens, those are isolated industries. Those are isolated industries. Corporate finance, regular, those are isolated, and there's no need for them, one of the lenses, to be, prolific in the other ones. There's no need. So by we tying all 5 together and being a plaintiff and being the first through the door, you literally shut the whole case down from the beginning without having to do any discharge process or send this document here or do that. You can go right into court and shut the whole case down before it starts. Shut their whole defense down before they get started. It is a rarity if you ever win on these claims at judgment. It will never get that far. I will be surprised if you won on judgment rather than on a settlement. When damages are based on the secondary market transactions or investor funded structure, we already did that. General arguments based on capital market structures always face difficulties when presented as defenses to contractual repayment obligations. 8, potential grounds for dismissal under Michigan law. Thomas presents the sections as if he were CAC's attorney. His 22 years of being in courtrooms, his 14 years of experience with the financial system, and input from a 27-year ex-SEC attorney and his business partner, a Series 7 securities broker and legal litigation expert, as well as over 80 cases reviewed by involving CAC. Under Michigan Rule 2.116 subsection C8, a court may dismiss a complaint for failure to state a claim upon which relief can be granted. A motion under this rule tests the legal sufficiency of the pleadings, not the facts of the case. the legal sufficiencies of the pleading. Pro se litigants, y'all have to get it out your mind that just because you think the facts are true, that's how the court's going to see it. The facts of the case and the arguments that you raise pursuant to those facts are two totally different things. The defendant could and may certainly argue that even if all factual allegations were accepted as true, the complaint does not establish a legally recognized cause of action because the theories rely on accounting standards rather than legal duties. Tax provisions cited do not govern contractual repayment obligations. The complaint lacks supporting case law and the biggest issue plaintiff faces. Certain statutory claims do not plead the required elements. If the court determines that the complaint fails to allege a legally cognizable claim, dismissal may occur at the pleading stage, meaning CAC will most likely move to dismiss after their initial response. You see that? AKA summary judgment. If plaintiff is lucky, CAC may move to compel arbitration. Given the structure of plaintiff's pleadings, this will be a fortunate thing for him. If they even move to compel arbitration, that is a big win for him. You're lucky to get that. Now, 9, likely litigation response from defendant. A defendant responded to the complaint will likely pursue early motion practice. Potential procedural responses may include the number one thing in which he lost, a motion for summary disposition under Michigan Rule 2.11. Exactly what credit acceptance did. I told him they was going to do that. Wanna know why I said, you want to, brother? Because if I was them, I would have moved for summary judgment against you. Yo, if I was the universal lawyer just for all these fights, let's say everybody that's in these spaces, if all the law firms hired me to respond to your guru's complaints that they be drafting, I'll be rich and it'll be no effort. It'll be no effort. I will be scalping the shit out of these social media gurus' filings. Oh man, overkill. The easiest money I make. They wouldn't even know how to respond back. When I respond back, first thing I'm responding back to, motion to dismiss. All right, the judge being low fair, I know they pro se, summary judgment. And then I'm going to play the procedural game with them because I know they don't understand court procedure the way I do. I know they don't understand it. So I'm just going to nitpick the hell out of them with the procedure. Every filing that they file that's not in line 100% with the rules of procedure, I'm going to file a motion to strike. It's going to keep striking their shit off the record. Yep. May ask for a motion to continue just to do it. Stall about. Because I know pro se litigants, they like to worry. They be in their head too much. See, I'm on this side of the fence. So if I went to that side, I already know how these people think. File a motion to extend time to respond. I already got my response ready. But it's the anxiety that I know that's building up with them. And instead of responding exactly to their claims, I'm just going to keep throwing a motion to dismiss, motion for summary judgment, because I know psychologically that's going to create something for the plaintiff. It's going to get them even more worried. And now all I need them to get is into the emotional, personal, I'm mad, they're doing me so wrong, it's a conspiracy mindset. I got the case won soon as they get there mentally. Now I really got the case. I'm just stringing them along. Get them dead to rights and be like, hey, you know, we're willing to settle. You don't mind settling? Oh, you don't? Okay, I'm just going to take everything you have. Yeah, it will be easy. We don't make it any harder for these people. And I told this brother, do not withdraw that. You're going to lose. Oh, you should have heard. I know what I'm doing. I teach a class too. You're not the only one that know. Well, I beat credit acceptance and you lost to them. They beat you. Yeah. I beat them, but they beat you. You thought you was going to be able to copy and paste, bro. They was salty behind that. They went back to the drawing board and tightened up the screws. Do you think they're going to be settling with people now, setting precedents? You really think, you know how many things just fell in line for me? Number one, I was in the right state. Number two, all the stars are lined up. They not settling like that. Credit acceptance not settling. They're not settling at all. They didn't even settle with the government. They didn't even settle with the federal government. They defended. They defended everything. They always show up and defend. They settled with me, though. Because as I told my Supreme Elite Team group last year, where the CFPB couldn't go, I could go. What the CFPB couldn't get done, I could get done. What the government couldn't do, I could do. You notice credit acceptance never, ever responded to either the complaint or the temporary restraining order. You notice they never even responded. They didn't even respond. Straight to settlement. As soon as their lawyer made an appearance, first day we talked, settlement talks. And they waited a week to hear from me before they even made their appearance. And why did they wait a week? Because their first email the lawyer sent, it went to my spam. I didn't even notice it was in the spam till 7 days later. Thank God I got a policy. I just don't erase my spam. I go check all my spam files before I erase the spam. And I seen it was a lawyer. I seen it was January 22nd. He sent that email January 15th. Did not make an appearance. After we talked, then he made his appearance. In a real way. We do this in real life. When the cameras is off, we grinding in real life. The Supreme Elite Team is grinding in real life. Yeah, it's game, fun, and entertainment on here, but this ain't no game. It's not a game. What's funny? Who playing? Yeah, we play the game to win, but this ain't no game. You think this is a game? You think these people playing? These people ain't playing. You think when they come to take your house and take, you think they not playing and they not going away? You got to get dirtier than them for them to respect you. I took credit acceptance. I will get dirtier than you. You got to pull out all the stops every time to beat these people. I'm talking about the system in general. It's not no, these people ain't playing. Oh yeah, the Center's international promise. You child's play. You playing. These gurus out here playing. The New Culture Empire, we not playing with them. In the event the defendant makes any such motions, it typically means that the complaint relies on financial accounting theories not recognized as legal defenses under applicable contract law. The courts will not automatically disregard the binding nature of retail installment contracts lightly. And the fact that plaintiff did not cite one single case authority is a serious concern. Man, I told this brother this. I told this brother, bro, no, even though you cited my shit, withdraw this. The professionals Thomas consults with stated that this complaint will be dismissed and CAC will pursue collection authority, including any past due amounts that have accrued. That's right here. That's exactly what they said. And you know what's so crazy? When I sent it, hey, yo, let me get your opinion on this. In 30 minutes, I got a response back. That's when I knew, oh, he's going to lose. This case will be dismissed. He will not win this case. When I got the response back, I said, oh, yeah, it's horrible for you. And I told him that. I said, bro, my professionals, people that I know, they literally said, you're about to lose this. No, well, I disagree with your model. I disagree with your findings. That's what he said. These are my findings here. He said, I disagree with them. Okay. So you disagree with a person who just beat the same people you're trying to beat. The pride and ego of pro se litigants in this space is half the reason why they lose. If I was him, and I know he just came off a victory, and he's nice enough to even give his time and energy to even converse with me about this, I'm going to shut the fuck up. And my next question is, all right, how can I pay you to help me? Motherfucker, you just won. Nope. Every pro se litigant thinks that they can step into these courtrooms and they don't even understand the rules of procedure of the courts in a sufficient way to help them navigate through all stages of the proceedings. What if it gets to trial? You know how to do your jury instructions? You know how to ask questions when you panel a jury? I was front row seat in my federal trial. I know exactly what questions to ask them. Well, I know what that process is like. What about your divorce jury instructions? Proposed jury instructions. You know how to write them in a way that's in line with the court rules of procedure? You know how to object? You even know how to strike a proposed juror? Do you know how to play to the jury in trial? You know how to play to them? Overall legal assessment of plaintiff's complaint. After reviewing the complaint in its entirety, including its legal theories, structures, and cited authorities, the pleadings raise significant concerns regarding whether it satisfies the procedural and substantive requirements necessary to survive early motion practices. The complaint appears to rely heavily on financial accounting interpretation and securitization theories, while providing limited reliance on binding judicial precedents supporting the legal conclusions asserted. And that's the problem. They can never find case law to support their accounting claims, their SEC claims. They can never, because you want to know the type of case law that supports that stuff. You won't even think about looking up those cases because it's so unrelated to consumer obligations. What? How the hell did you? Courts generally require complaints to demonstrate not only factual allegations, but also a clear legal basis showing that the asserted claims are recognized under existing law. Although the complaint cites various regulatory materials, including federal accounting standards, a pro se trap, and SEC disclosures, another pro se trap, the pleading largely fails to identify controlling case law demonstrating that such authorities create a private cause of action or invalidate a consumer finance contract. Hit the QR code, scan the QR code, reserve your seat for the professional, reserve it, join the Patreon. SETu is in the Patreon now. The first 6 classes of SETu is in the Patreon. I believe first 5. 6 will be uploaded if it's not there. The mortgage reality. It's in the Patreon. Join it. How is it that the new culture, everything that these pro se people lose on, I won off? See, that has to be studied. How is all these people losing on the accounting and SEC, but you won? Because I don't think like a pro se consumer. I don't think like a defaulted borrower. I think like them. Because courts resolve disputes based on statutory authority and binding precedents rather than accounting interpretation. The absence of controlling legal authority raises questions regarding whether the complaint could survive a motion to dismiss. A central premise of the complaint is that the defendant's securitization structure and accounting treatment transformed the consumer loan transaction into a securities lending or secured borrowing arrangement. Right there, he copied the hell out of me without any case law or other supporting evidence to back up such claims. However, the complaint does not cite judicial precedents where courts have accepted such arguments to invalidate or recharacterize consumer installment contracts. This omission is significant because courts generally require plaintiffs to demonstrate that their theory has support in binding precedent within the applicable circuit or persuasive authority from other jurisdictions. He took my gift. He took it, which ended up being his curse. God damn it. He took my gift, and it ended up being his curse. Because if I was drafting the complaint, I would have drafted the complaint based on his facts and circumstances. Every lawsuit's going to look different. Remember, he was the plaintiff, but they already repossessed the vehicle. You can't bring none of this. Nah. If you are plaintiff and current, we're going to smash through the door. If you're the defendant in default, we're going to make it hard for them to collect and win. The litigation research reference indicates that prior to the filing of the Thomas complaint, no reported federal or state decision had raised or adopted the same securitization recharacterization theory presented in the pleading. Courts have historically treated securitization as a financing mechanism that does not alter the borrower's contractual obligation. Without precedent demonstrating that courts recognize this theory as a viable cause of action, the complaint may face difficulty establishing a legally cognizable claim. The complaint relies on the ASC. These are not consumer-facing statutes creating a private right of action, nor do they independently determine contractual liability between private parties. The courts distinguish accounting treatment used for financial reporting and legal rights and obligations created by contracts or statutes. But this is invalidating the whole accounting space, because in these spaces, y'all, they use accounting as another way to say, I don't owe. You got paid. You can't show injury. They use securitization to show the debt's already been paid. I don't owe. Two of the main reasons why they use accounting and securitization, which will lead to a loss, is what's been actively promoted in these spaces every day. But when I come and say none of that's going to work, I'm the bad guy. I'm the agent. I must be an agent now. I'm an agent working for the ops, trying to block your remedy, trying to keep the truth come out. Well, why did the agent win his own case? If I'm the agent. And they only say that when in a way to stifle conversations that makes them uncomfortable, or shut down anybody who is thinking differently or not believing or consoling them and confirming their belief system. That's the way to stifle that. Gaslighting is what we call it. Because the complaint appears to treat accounting classifications as determinative of legal liability, courts may view these arguments as outside the scope of judicial enforcement unless tied to a recognized statutory claim. Bam! Which plaintiff has not done. As for the fraud argument, the who, what, when, where, and how elements were not satisfied, and this claim will be dismissed because the elements of fraud was not pleaded with particularity. I might as well be a judge saying it, because that's all the court's going to say. Court's going to say the same thing. The overall compliance with the pleading standards was also not satisfied. Complaints must satisfy procedural rules requiring a short and plain statement of the claim showing the entitlement to relief. The complaint review here spans extensive discussions on financial structures, accounting rules, and regulatory materials, striking similar to Thomas's complaint. But it is less clear whether the allegations are organized around specific legal causes of action supported by controlling precedents. In fact, there is no legal authority for the myriad of claims. All courts, both state and federal, require complaints to clearly identify the specific legal claim being asserted, the elements of that claim, factual allegations supporting each claim. The problem in these spaces, in these pro se spaces, is that they never get to the specific legal claim being asserted, the elements of the claim, and the factual allegations supporting each claim. What the courts tell you not to do if you want to survive a Rule 12b-6 motion is what's actively parroted and taught in these spaces. What the courts tell you not to do is what they tell you to do in these spaces. But we want to win, right? We want to win. It's not about winning. It's about being right in these spaces. They just want to be right. And nobody can silence anybody to come in to say I'm wrong because I don't want them messing up my money. That's all it is in these spaces. But it's the borrowers, it's the students, it's the clients who's paying with their own property and their livelihoods. These little games these gurus play, y'all paying for it with real stuff. And they're never around when things blow up. The gurus are never around. They're never there to fix the problem they help create. They're never there to fix it. I've talked to over 50 clients of people in these spaces. They all have the same story. It's always catching the attitude like you inconveniencing them. It's always, well, do your research. Oh, you should take it from here. Hey, I ain't tell you to do that. When you clearly instruct them to do that. It's never from what I've spoken to these people, the conclusion is it's never the guru's fault when the client and the students lose. It's never the guru's fault. It's either the system, it's either the conspiracy, or it's something that the student just didn't do right. The legal framework presented in the complaint bears notable similarity to the litigation approach developed by Thomas versus Credit Acceptance in August 2025. Prior to Thomas's lawsuit, his team searched every state and federal lawsuit filed against CAC dated back to the early 90s. Not one single argument Thomas raised was ever advanced by any consumer involved in litigation against CAC dated back to the 90s. Thomas litigation advanced arguments involving securitization structures, ASC accounting standards, recharacterization of consumer finance transactions. The present complaint appears to adopt several of the same conceptual arguments and structural theories, although the litigant has asserted that the case was developed independently. Yeah, right. Since the court research from every state and federal jurisdiction prior to Thomas's lawsuit suggests that courts had not previously seen these arguments raised in the same manner, it indicates, and CAC will most likely observe the same, that the litigation approach, rather than, and CAC will most likely observe the same, that the litigation approach, rather than established legal doctrine. Courts typically approach novel legal theories with caution, particularly where they rely heavily on regulatory interpretation rather than established statutory or case law authority. Sidebar. This is the 5th consumer in the past month who has presented their lawsuit against CAC, and all of their now lawsuits all resemble the same arguments Thomas advanced against CAC. AK10K citing 26 CFR 1.118, accounting similarities. Thomas's complaint incorporated supporting case law and legal authority to frame the arguments. The present complaint cites virtually no controlling precedents. No one cites these highly complex claims out of the thin air. And if research were done independently, they would most certainly include case law. This distinction suggests that while the current litigant may have adopted similar conceptual arguments, the filing lacks the necessary jurisdiction-specific Michigan legal authority required to substantiate those claims in the applicable court. This omission may indicate reliance on copied or derivative arguments rather than an independently developed legal analysis. Credit Acceptance will more likely not take this complaint as serious as they did Thomas's. This is where the "you're rocking with the best" comes in at. Absent of legal research independently of Thomas's, CAC may view the complaint as a replica in form, but not substantiated with the legal analysis necessary for the court to evaluate their viability. Also, the claims raised here should have been brought in a federal court and not in a state court. This venue may not be equipped to deal with plaintiffs' overlapping of claims asserted in this complaint. I get so tired of seeing you pro se litigants cite AFC, cite fraud, cite securities, going in a state court. You're asking to lose. You want to know why? Because all they're going to do is remand it to federal court. Rule 12b-6 is coming right down the pipe. And you're going to file your little objections. You're going to file your little objections to keep it there. Nope. Nope. Not going to succeed. The fifth person. And you know they can't help because they got to send it to me. But this is the disingenuous part of all of them. They're sending pretty much a copy and paste of my work back to me in hopes to get me to believe that they are on my level with the legal research. And not one of those 5 cases ever had case law to support it. So they send it to me like, I copied you, but I want you to think that, yeah, I'm on the same level as you. I did the same research as you. Motherfucker, you copied me. In these spaces, y'all, they don't want to give nobody their props. Just say it. I'm like that with the litigation. I give props to everybody who's like that. I'm the first one to give them their praises. I don't have a hating bone in my body. I've never hated on nobody. If anything, I use their success as motivation to fuel me. Damn, he doing it. Yeah, I gotta get my shit together. Shit, I gotta get my shit together. That may motivate me to get my shit together. But I've never been a hater. And the reality is, people has envied the new culture success. They may not come out and say it because I did it a different way from what they spent their money on, the time invested, and their perception of reality. Because the new culture empire, Supreme League team success, to them is telling them that they're wrong. It's telling them that their belief system is wrong. The complaint appears to demonstrate substantial effort in research regarding financial regulation, securitization structures, and accounting standards. However, the pleading suggests that the litigant may be more familiar with financial theory and regulatory disclosures than with the procedural and doctrinal framework courts use to resolve disputes. Successful litigation generally requires integrating financial, corporate finance lens, regulatory arguments, regulatory lens, within established legal causes of action supported every step of the way with at least 3 to 5 case law for each argument. When such integration is absent, courts will often conclude that the pleading does not present a legally actionable claim. In a real way, in real life, and this is what I mean, the 5 lenses of the contract cannot be duplicated. You cannot put that in the chat. You can't. It's never going to spit out exactly what I'm telling you. It has its own general stuff it's going to look at. It's going to look at the general regulations and the rules, and it's not getting deep into their side. It's not getting deep into, because that's stuff that you have to know. You have to do the deep research. I didn't pull the 5 lenses out my ass. I worked on that for almost 4 years straight with over 50,000 documents. SETu is taught around that. I created a whole university from scratch around that framework. No, you can't put it in any model. No one can. It's literally crafted from the ground up. I guarantee you, if I hand you my SETu 5 lenses of the contract document, is going to say everything is going to be totally different. Remember, some documents that I use to rely on the understanding to build it, it's not even publicly available. Ask the Supreme Elite team. Ask Darren and them. Bro, we was reading from documents from staff, like faculties, like stuff that's not even public. Hey, for private use, not for public consumption. That's on at the bottom of each page. God damn it, I got the OCC, Office of Comptroller of Currency Employees Handbook. I got their handbook. Because when you're connected to professionals, you get access to certain things. That's all it is. Not even a big deal. Probability of success. Based on the structure of the complaint and the authorities cited, the claims may face significant challenges at the early stages of litigation. Defendants in similar cases commonly file motions challenging the legal sufficiency of the complaint, not the allegations raised. And that is what pro se litigants don't understand. You think when they respond to you, they're responding to your facts. They're not responding to your facts. When they respond, they're responding to the legal sufficiency, the procedure, and the rules of your complaint or the lack thereof. Stop thinking that they responded to what you're saying. This is, see, it's two totally different views. You got you're viewing it one way, they're viewing your complaint another way. So when I look at your complaint, I'm not looking at it the way you see it. I'm looking at your complaint in a manner in which the other side is going to look at it. And I'm going to nitpick and take apart everything that you're saying, or try to. Why? Because it helps strengthen up your game. Because if I can see the holes, they're going to spot the holes out a mile before I can. We got to get out of this kumbaya, let's bond together. Yeah, you made good arguments. We got to get some type of professionalism in the complaints. We got to get some type of professionalism in drafting. Y'all, it's sloppily drafted. A lot of this stuff, you're all over the place. You're not citing the statutes correctly. You are not arguing the statutes correctly. You're incorrectly citing the statutes. You're incorrectly raising the claims. Some of the statutes and the claims that don't even have no legal validity, you're citing a bunch of nothing burger arguments. A lot of time and energy is wasted on things that the courts is going to view as a nothing burger. You're not getting to the actual rules and procedure of court. Want to know why? Because it's easier said than done. Because it takes time and years to understand how courts work. You're 2-3 years into this. No, you need a minimum of 7 to 10 years before you can understand what's going on. Based on the structure of the complaint and authorities cited, the legal claims face significant challenges at the early stages of litigation. Defendants in similar cases commonly file motions challenging the legal sufficiency of the complaint, not the allegations raised. If the court determines that the complaint relies primarily on accounting interpretations rather than recognized legal doctrine, the case could be vulnerable to dismissal. In such case, CAC will get very aggressive with the collection efforts. While courts permit pro se litigants some procedural latitude, they must still present claims grounded in enforceable law. Final conclusion. The complaint reflects significant research and effort in examining the financial and securitization practices of the defendant. Plaintiff made the fatal mistake many pro se litigants make in consumer litigation, arguing the lawsuit from the consumer lens. Just like many pro se litigants, the plaintiff cited virtually no case citation to support his accounting claims. He cited the SEC filings without any supporting law and failed to plead the standard in fraud claims. The structure appears to focus on financial and securitization theories and structures rather than established legal precedents. The complaint shows an inexperience with case law research and controlling precedents. One thing that CAC will spot from the onset. Another fatal flaw is that the plaintiff seeks return of proceeds from the securitization. That is a settlement and successful case killer. Plaintiff raises arguments that courts have consistently rejected as prima facie evidence of a plausible claim. This report suggests that CAC will most definitely move for a motion to dismiss or summary judgment after the pleadings are closed, and the court is more than likely going to grant it. Court is 98% rules and procedure and 2% facts and arguments. Now, let's just take a look at what was the disposition of this case. Remember, this report suggests that CAC will most definitely move for a motion to dismiss or summary judgment after the pleadings are closed, and the court is more than likely going to grant it. Hold on, TikTok. Let's just see. Let's just see if I was correct. 1 second. Because I got to get on my phone for a second. Let's just see if I was correct. Let's just see if I was correct. You know me. You know one thing. You know one thing that when you like to be, not like to be right, like to be right. But you know when you kind of hate to be wrong? I hate to be wrong more than I like to be right. So you know what that means? I make sure, I don't talk out the side of my ass when I put a report together. You best believe, when I put a report together, I've been batting 1,000. I don't bat 1,000 for no reason. This is his case. This case right here. Oh, God. Here we go. So, and this is it right here. So, on March 2nd, 2026, a month and some change after my settlement, I gave him the confidence to go file against credit acceptance because I give people confidence. A lot of people be scared. I give people confidence. I give people hope. So at least what I did, I gave him hope. If he would have listened to me, took my advice, or at least allowed me to draft the complaint against him, he would have had a better outcome. But no, the pride and ego amongst the pro se litigants, they all think they could do it on their own, and they don't even realize when they're walking themselves off the fiscal cliff. Less than 5% of pro se litigants ever win their cases. And the problem with the pro se litigants, you're looking at it from a way that legal professionals would never look at it. You can't help but be personally involved. You can't help to you can't help to throw so many darts off the wall hoping one sticks. Professionals, we don't move like that. So the complaint was filed March 2nd. So you got the miscellaneous motion filed. And then he filed on the same day motion for injunction. On the 6th, 4 days later, the order denying the motion. Do you hear that? And then the service of complaint. And this March 17th, pressing fee notice of hearing filed. On the April 1st, affidavit and notice of entry of foreign judgment. You see what I'm saying? Brief filed on the April 2nd. And on April 2nd, what did credit acceptance file? motion for summary judgment disposition on April 2nd. And they had a hearing on April 3rd. On April 3rd, the motion was denied. April 14th, order to set aside, sign it. April 19th, order for miscellaneous action. Proof of service. And April 20th, they filed an answer to the motion. And then his order denying the plaintiff's motion, Mr. Carlos. Right? Now, on May 21st, closed, final, order, summary judgment, disposition granted for Credit Acceptance Corporation. And then the brother filed May 26th, a motion for reconsideration with affidavits, exhibits, briefs, probably much more copying. And look at that right there. June 2nd, they canceled the status conference, dismissed the hearing or injunction. And now the brother has to pay the balance and the costs and the fees as of July 8th, 2026. Basically, let's go back here. Go back here. Let's go back here. What did I say? What did I say? This report suggests that CAC will most definitely move for a motion to dismiss or summary judgment after the pleadings are closed, and the court is more than likely going to grant it. Well, you just saw it. The court granted the motion for summary judgment back in May, as I knew they was going to do when I told the, oh shit, I didn't mean, what's going on? I didn't mean to do the challenge right now, but since we are right now, hit the challenge, y'all. You want to battle? You want to battle? Battle. Let's get it. Hey, y'all. Yeah. New Culture Empire. I need y'all. Let's initiate the battle, because I don't know how to do it. But initiate the battle. Let me see if I can initiate the battle. Chelsea. Initiate the battle.
Okay, how do you do that?
I'm just as lost as you. But since you're here, initiate the battle. Y'all, we need to get this battle started. She jumped in the line of fire. I got it right here. All right. Let's go. Hold on, I just hit the battle. Come on, y'all. I need y'all to come on, y'all. Let's hit this battle right quick. Since you want to jump in the line of fire, let's jump in it. That battle. Well, Chelsea, you try to figure it out in a second. I'll get back to you in a second. But yeah, scan that QR code. Yeah, this is what happens. I told y'all, this is what happens. And it happens all the time. But let me put y'all over here. TikTok, put y'all over here. This happens all the time. But you know one thing? YouTube, what they can't do is say that I won too. That's what they can't do. But I don't know what I'm talking about. Credit acceptance. I don't know what I'm talking about, though. Whatever, hide. Right there. Y'all can see it. Yeah. Whatever. I don't know what I'm talking about. So when I was talking to him, I wasn't talking to him as a person that I was just trying to, damage pay. Bro, I'm talking to you. I just beat them. I know what it takes to beat them. What you did is not going to beat them. You're going to lose. Regardless if you copy me, you still ain't doing enough. You think you could just copy and paste and that's enough? That's all you got to do? These people ain't playing. It don't work like that. You wish it did. It don't work like that. You just copy and paste and that's gonna be it. It don't work like that. It don't work like that. You gotta put that work in. 16 months. I put that work in. Sleepless nights. Wake up at 7:30 in the morning. Ain't eyes till 3:30 the next morning. Three more hours. After class is over. Oh, started class at 7 o'clock. We ain't log out to 12. I get into bed about 12:30. I ain't fucking close my eyes till 3. Studying, grinding, because I'm trying to beat these people. And I know while everybody else is asleep, I got to be up. You want to know why? Why I'm still up while everybody's asleep? That's practice. That's repetition. That's 3-4 more hours a day that I got over the competition, over them. Times that by 16 months. I then got fucking 40, 50 hours over the average person. While people, these gurus online sleep, I'm up. This is why you can tell the difference between us and a lot of these gurus. It's not because anyone's smarter, more intelligent. We got more time and hours in the research. So we can go in deep waters where when these gurus, their understanding stops and they start to guess, like Tori Martin, you see how she was just guessing and trying to figure it out, or just throwing, or you could do it like this. No, see, over here, we go so deep down into it to the point where, yo, you wouldn't even believe the recent IRS success. I didn't even post the shit. I saw it yesterday. I didn't even tell the Supreme Elite Team group yet about it. Because when it becomes so what you're supposed to be doing, so we're supposed to be getting these results. Okay. We about to go now. Ready to church? Ready for church?
Cool.
Yeah, cool. Church and cool.
Cool.
Yeah, church and cool. You happy for church? All right. Y'all, let's get ready. Start getting ready. Y'all vacation Bible school. Let's get ready. You know what I'm saying? That's how it goes in real life. I'm not telling you anything wrong. I'm not telling you anything wrong. Actually, what I'm telling you is to help you. I've been through the fire with these people. I know what rejection feels like. I know what getting your ass handed to you by their lawyers feel like. I know what losing by a smidget feels like. I already know. I already been through that. Man, when I first started, I was getting my ass handed to me. Procedure, rules, procedure, sufficiency. They just kept pounding me. I'm like, damn, they just. So now I was like, you know what? Let me start learning what they know. I want to know about the rules and procedure, how they know. Worst thing they could have ever done. Worst thing they could have ever done. That is the worst thing. Ladies and gentlemen. Before we get there, July 14th, the professional for Fannie Mae is tuning in. He's giving a presentation. You're going to learn about mortgages after the closing. You're really about to see what's going on from their side of the fence. You're going to learn about mortgages. Scan the QR code, TikTok. You already know it's to the DM. We getting it in. And I'm going to be in the audience just like y'all with my pen and pad, taking notes from a true professional. Who else do you know that can bring a Fannie Mae senior supervisor in? And if you can do it like that, yes.
I'm not going.
All right, they're going. Okay. All right. Okay. All right. Where they at? And you notice how they want to have their webinars on July 11th. Notice how they got theirs on July 11th. They got their webinars July 11th. Ain't been I told you, they copy me. They copy us. We're someone to copy. We're someone to take a look at. We're someone to keep notice. Let's do it.
Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we won cause we plan. The things that they teach, don't know how to stand. I'm a wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay, I cannot help that they copy. Hey, I am that dad, call me Poppy. They wish they created the set. Yes, they on my D like a jockey. When it comes to the print, I'm the blue. Who? Every complaint, draft is smooth. Supreme Elite team be the ones. Yo, I created my own school. Facts. I came from the trenches. I came from riding them benches. To proving my case with exhibits. My craft is exquisite. I find where they hiding them digits. The cancer that's not in remission. Hey, please pay attention. You can't recreate the 5 lenses. You can't duplicate what is written. You either gonna pay the tuition or pay for assistances. Or pay the mistakes when you case it, dismiss them. I come with everything that's under the kitchen sink. I haven't slept in a week. They scared while I'm willing to compete. These scammers are devils and I keep them under my feet. Hey, they saying they win, I never take their prescription. They never coming from the plaintiff's position. I am the blueprint, blatant admission. Check it, when I talk classes in session, professionals, even the tacos respect it. Show me a win, that's not a rejection. Tell me the truth without all the stretching. These gurus are boring and it's stretching. These students are dumb, desperate depression. SETu, yeah, I'm done with this lesson. Came from the streets, still I'm a step up. Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. On the things that they teach, don't know how to stand. I'm a wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay. New culture, he running this shit. Like he came with a gun in this bitch. And he double up wins back to back. Like he ain't even done with this shit. Now come to court like a dog off the leash. Dismantle the evidence, break down their claims, and he start from the top of the sheet right here. Whenever he talk, they retreat. He's a lead with his team, they supreme. He brings reality out of drink. Okay, they can't help but watch from the clouds. They trying the words and the memes. Alibi with the feds. You fuck with alibi, you be in the feds. Lawful levy, still a rookie. Can't stand on the shit that they saying. Hey, he beat his case, he beat CAC to submission, stipulated the disposition. Westlake, he tried to give a break. Attention they didn't wanna pay. Made them max sit, they on case. Get the fuck out his face. The new culture ain't wanna play. The new culture running this shit. The new culture with debate. Anyone who think they running this shit, he take your docs and expose that shit. Gon' be acting like you never sold that shit. They copy his drip like he sold that shit. Ain't no guessing with him, gotta know that shit. Hey, you gotta know that shit. He be credit acceptance, I be Westlake. Whatever I'm serving, they eat the plate. They don't watch me loud, but they watch from the clouds. They copy my style, but can't figure me out. The 5 messages I created that you can't duplicate from an AI chat. He think of things that they can't comprehend and teach what people did not know exist. Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach, don't know how to stand on my wrist.
You're rocking with the best.
I thought so. Okay, in the blueprint, if not, why you copy me, fam? I thought so. Okay. I thought so. Okay. I thought so. Okay.
You're rocking with the best. You're rocking with the best. You're rocking with the best.
All right, y'all. I'm on my way to church. I may tap in live with y'all at church. Let's go. One gone.